which means that the disablement of this tracking device was not a matter of a technological failure or something to that effect. Interference with this device on the day that Sharon was abducted and later killed is a strong basis upon which a strong inference can be made with regard to the preparation and concealment of the purpose for which this device was made unfunctional. It demonstrated planning and intention to avoid detection. The prosecution also adduced evidence to prove that on the 4th September 2018, a day after the offense was committed, the third accused introduced the second accused to PW22, requesting him to procure fake medical records, which were generated by PW20 on the request by PW22. It is apparent from the above fabricated medical reports that they were meant to support a report made at Oriri Police Station to PW3 on the same day by the second accused, claiming that he had been abducted by unknown people on the previous evening, in the course of which he had been beaten and robbed. Investigations revealed that this report by the second accused was a false report. And this is what meant to his arrest at Oriri Police Station. And though though both the second and third accused persons denied having ever requested PW22 for procurement of these false medical reports, they failed to explain how the said documents bore the second accused's name and personal details. Importantly, the second accused did not disown those details. The submissions made on behalf of the two accused persons, impugning PW22's evidence on grounds that he had handed over the documents to the second accused at around midday, when the second accused was already at Oriri Police Station, are, in my view, with a lot of respect, misplaced. They appear to be based on a misapprehension of PW22's evidence. PW22 clearly stated in his evidence that he handed over the fake medical records to the third accused on instructions by the second accused. He did not say in his evidence that he had handed over the documents to the second accused. In my view, the denial by the second and third accused that the denial by the second and third accused of involvement in the procurement of the forged medical records amounted to mere denials or afterthoughts, which did not affect the veracity of the two prosecution witnesses. These witnesses were independent witnesses in this case, and no reason was given by either the first or second accused that they had any reason to fabricate or give false evidence against them, against the two accused persons. That said, I agree with the second accused that PW 42's claim, that is the investigating officer's claim, that the second accused is the person who presented the false medical report or the false medical records to Oriri police station when making his abduction report, and that the investigating officer collected the medical reports from Oriri police station in the course of his investigations cannot be true. This claim by PW 42 was not supported by the rest of the evidence on record. There is evidence from the arresting officers at Oriri police station that at the time the accused was arrested, he was searched, and nothing in the nature of documents were found in his possession. The other reason that I have made a finding that PW 42's evidence on that aspect was untrue is because that claim that he had collected these false medical reports at Oriri police station where they had been taken to the accused person flies in the face of the letter dated 13th June 2022 produced by the second accused as defense exhibit 4, in which the investigating team was giving the second accused a notice through his advocates to produce original copies of the same documents. Having totally and thoroughly evaluated the evidence presented by the prosecution in support of his claim that the third accused jointly with the other accused persons or other persons not before the court execute in common with having thoroughly examined the prosecution's case, seeking to prove that the third accused planned in conjunction with the accused persons and in execution of their common intention to cause the death of the second to cause the death of Sharon. And having juxtaposed that evidence or compared that evidence with the evidence adduced by the third accused, I have come to the conclusion that the third accused was not a passive bystander, but was an active participant in the events that resulted in Sharon's death. His conduct of assisting the second accused to invent a false alibi to cover his tracks on the night Sharon was unlawfully killed is incompatible with his innocence. It is also noteworthy that although the third accused testified that he did not report directly to the first accused in the course of his duties, The data records produced by PW40 in respect of the first accused's mobile number, that is 0722469587, shows that in the 2 days between 2nd and 3rd September 2018, the first accused made a total of 5 calls to the third accused. The call data records produced as XB 64 show that the first accused made the first 2 calls on 2nd September 2018, and the other 3 calls were made on 3rd September 2018. The third accused call to the first accused was made on the following day, that is on 4th September at 7:31 p.m. The number of these calls per day and on days that were either just before or on the day that the offense was committed, and on the day subsequent to commission of the offense, give a reasonable inference that these calls were made for purposes that were connected to the offense that was committed on the 3rd of September 2018. Or for purposes that were in furtherance of ensuring that there was planning and coordination of the events that led to the commission of the offense on that date. I make that finding based on the timing and the frequency of those calls, and also because the content of those calls were matters that were within the special knowledge of both the first and the third accused persons. And under section 111 subsection 1 of the Evidence Act, the burden of proof shifted to the accused persons to explain the reasons that these calls were made, in the manner in which they were made, and in order to rebut the presumption that the calls had been made for an illegal purpose. The first and the third accused failed to discharge that burden. Having carefully appraised the evidence on record in its entirety, it is clear to me that the evidence demonstrated, it is clear that the evidence adduced by the prosecution in this case demonstrated and left no doubt that the accused persons acted in concert, jointly with others not before the court, pursuant to a common design, each performing a distinct role in furtherance of a criminal enterprise that resulted in the death of the late Sharon. To summarize, the first accused supplied motive, instigation, and funds to finance the criminal enterprise. The second accused facilitated execution where the third accused ensured logistical support and concealment to avoid detection of the offense. Inherent in these roles were acts of preparation and concealment, denoting knowledge, participation, premeditation, and intention to execute their common intention aimed at executing their common intention that ultimately led to the death of Sharon. These acts constituted malice aforethought as defined in Section 206 of the Penal Code. The fact that the first accused alibi that he was not in Migori County at the time the offense was committed, and the same was vindicated by the evidence that was produced in this case, and that he was in Nairobi from the 2nd of September all through. Even from he was in Nairobi from the 2nd of September. It was not therefore physically in Migori when the offense was committed. That's not meaning that he was not physically present in the place where this offense was committed. Does not shield him from criminal culpability, since under the doctrine of common intention, criminal liability does not depend on who physically commits the actus reus, but whether the accused acted in concert with others to execute an unlawful purpose. Applying the legal principles governing the application of circumstantial evidence to the present case, and having in mind the law regarding the definition of principal offenders as stipulated in Section 20 of the Penal Code, I am satisfied that the circumstances presented in this case, taken cumulatively, form a chain so complete that there is no escape from the conclusion that the accused persons, jointly with others not before the court, committed the offense charged. The evidence on record irresistibly points to the fact that the accused persons with malice aforethought unlawfully caused the death of Sharon at the material time. It is therefore my finding that the prosecution has proved its case against the first, the second, and the third accused persons beyond any reasonable doubt. I consequently find each accused person guilty of the offense of murder, contrary to Section 203 of the Penal Code, as charged in Count 1. Each accused is accordingly convicted under Section 322 of the Criminal Procedure Code.
We are most obliged.
Most obliged.
Most obliged. May I request that you guide us into the next phase of this trial?
So, councils representing the state, I do not, I do not know, and I seek to find out from the council on record whether they are ready to take directions on the sentence hearing, and whether the councils representing the state are also ready with information regarding whether or not the first accused person, the accused persons have any previous convictions or not, so that we are able to give directions on the way forward.
Yes, my lady. Apologies, I was late. I had a meeting that I had to attend. In regards to directions, we are ready to take directions on sentencing hearing. We would also like to be given time to get the reports on any previous sentences, so we can supply the same to the courts.
Just a minute.
We'd also be requesting the courts.
Okay, so start again, Ms. Kikwe.
My lady, I said that as for the Republic, we are ready to take directions on this matter. We do not have the previous convictions reports from the accused persons.
You are very fast.
Oh, sorry, I apologize, my lady.
You're saying you started by saying that you apologized for coming late.
Oh yes, my lady, I apologize for coming late. I had a meeting which I'd been directed to attend. But I had a team of 3 prosecutors who are here. In terms of directions, my lady, we are ready to take directions on sentencing. We'd also like time to provide, to request and provide to the court reports on previous convictions for the accused persons.
You'd also like time?
Time, so that we can request from the DCI reports on any previous convictions of the accused persons. So we can supply the same to this court. My lady, we'd also be requesting the court to order for pre-sentence reports from the probation department. the same to be supplied before the next sentencing hearing date that will grant us. My lady, finally, in regards to the judgment you have given, we'll be requesting that the 3 accused persons' bail bonds be cancelled and for them to be remanded in custody. That is all, my lady.
Mr. Awar.
Thank you, my lady. I support the applications made by the state. Safe to add that and to emphasize that we request for a specific order for preparation and supply of victims' impact.
To emphasize that?
We request for specific order to the probation officers to prepare and supply us with victim impact statements prior to the date that will be set for sentencing.
That the probation officers prepare
and supply as well victim impact statements under the Victim Protection Act, Section 12. And the same be done prior to the date that the court will set for sentencing. Thank you, Mary.
Counsel for first accused.
Your Ladyship, I wish to address you on the request for cancellation of bail. That's the only issue I wish to address you on. Your Ladyship, the preparation of the reports from probation officers, including the victim impact report.
The preparation of the report.
Probation, yeah, pre-sentencing reports which the prosecution has requested, and the victim impact assessment reports. The preparation of those reports takes time. And so the date for sentencing is likely to take into account the period that will be taken in the preparation of those reports. Your Ladyship, the request by the prosecution to cancel the bail to which the accused persons were admitted to is not an unusual request. people are admitted to bail on account of presumption to innocence, which has now fallen off.
Okay.
However, your ladyship has judicial discretion.
Just a minute, Counsel, so that I do not lose you.
Yes.
You are saying that the preparation of these reports
Will take time.
take time.
Yes. In fact, most likely more than 30 days from experience will be taken in preparation of those reports. And I am saying the request made by the prosecution is reasonable, because people are admitted to bail on the premises that they are presumed innocent. That presumption has fallen
Slowly,
off
slowly,
today.
Counsel.
Yes, sorry.
Yes, go ahead.
So, your ladyship, I was saying, with the guilty verdict that you've rendered today, that presumption falls off. However, the court still has discretion to extend the bail terms up to the date of sentencing. Your Honor, in respect of the first accused, he was released on bail on the 24th of October, 2018.
On 20?
On 2018, on 24th of October, 2018. That's when he was released on bail. And your ladyship, for the last 8 years, he has dutifully attended court whenever required. His passport, including his diplomatic passport, is deposited with the court. I ask your ladyship, in view of these circumstances, to consider extending the bail terms to the date of sentencing. That is all, your ladyship.
Okay, Counsel for second request.
Thank you, my lady. Lady, on behalf of the second accused, we are grateful for the judgment you have rendered. and we take cognizance of the submissions by my learned colleague, the prosecutor, save as to my lady, since when the second accused was admitted on bail, he has religiously attended court and even on the single instance when he didn't attend, he provided an explanation which the court didn't give a finding of doubt on the same.
Since the second accused was admitted to bond,
He has been religiously attending court, my lady. And on the single instance he didn't attend because of the reason for illness, evidence of the same was tendered before court, my lady. And to associate myself with the submissions of my learned senior counsel Kilukumi, this court has discretion to extend bail until the date of sentencing, my lady. Which we hereby humbly ask the court to consider. That the accused be allowed to continue enjoying bail until when this court shall render sentencing. And again, we agree with my learned senior, my lady, that the sentencing report may take a while. We humbly pray, my lady, that's all.
counsel for that.
My lady, on behalf of the third accused, we also thank you for the judgment. My lady, to avoid rehashing what my colleagues for the first and second accused persons have said, first, we are ready to take directions as to the sentencing hearing. And in relation to the application for revocation of the bond and bail terms, on behalf of the third accused, my lady, we also pray very humbly that you be pleased to extend the bond terms of the third accused person. My lady, I will adopt mutatis mutandis, the reasons afforded by my learned senior Kilukumi and my colleague Mr. Ogada. And just as a confirmation, my lady, the third accused person has also religiously attended for the last 8 years. And we'll pray, my lady, that you be pleased to exercise that discretion in his favor. Lastly, my lady, in the intervening period, my lady, we will pray that, and I believe I have seen my lady with a printed copy of the judgment. We will pray that if the same is ready, we'll be supplied with a copy of the judgment in the intervening period. Even as we wait for the sentencing hearing. That is all, my lady.
Okay. So, Ms. Kwe, I don't know whether you have any response. Before
I'll probably leave it to court. The practice has always been for bail bonds to be cancelled once a judgment for guilty has been provided. So on that aspect, we leave it to the court.
Okay. So I do not know what is the practice in Nairobi regarding the time it takes for preparation of these reports, so that that can guide us in determining the return date.
Yeah, it will depend with where the victims, their geographical area, and the accused person's geographical area. So, like Homabay, it will take maybe a month.
All right. Okay, everything considered, considering the submissions that have been made by the Learned Council on record, the application made by Ms. Kikui for the state, and the responses by the Learned Council, I will take that into account when giving the directions that I'm about to give. And the directions are as follows. The case is adjourned with the following orders: that pre-sentence reports shall be filed by the probation department within the next 21 days. Victim assessment report to be filed within the same period of time. The reports, once filed, shall be shared with all the parties. We can get a date after the 21 days when the matter can be mentioned to confirm that those directions have been complied with. And pending that mentioned date, the accused persons shall be remanded in custody as their bonds have been cancelled.
Your Ladyship, are we going to have a mention and then we fix a date for the sentencing? Or we are going to fix a date for the sentencing?
I was thinking that we can take a date for the mention first so that we confirm that the documents are filed, so that we can now take a date for the sentencing hearing knowing that we have the documents are ready, so that we don't take a date for sentencing and then it does not take off for lack of the filings. And the reason I give 21 days is because I thought we could expedite them without having to give the period that was estimated, that the time that they usually take is more than 30 days.
Yes.
Yes.
So, Your Ladyship, can we mention, subject to your diary, on the 17th of August? I suspect that may be vacation time, and we may need your guidance as to which date you are available. We could probably make the mention virtual, so that we make things easy for everyone.
I think that's reasonable.
Yeah. Do we take then the 17th? Virtual mention?
17th of August.
Is it convenient to all?
It is convenient. It's only that judge says, will the judge remember?
My lady, I'm saying it will be a Monday. And,
Is it a Monday?
Yes,
Yes, it's a
and we've
Monday.
had a few issues with Monday, my lady. You know that. Maybe
We
we
can make it 18.
we can have the
That's a
Tuesday.
If that's comfortable for the court. But you could give us time indication.
I think 11 is a good time.
Yes.
Yeah. So at least, my lady, on Monday we can remind Mr. Kinywa to remind the court.
No, it's okay. I'll remember. It will be recess time. I will not be working in a different station with a huge cost list. But we have taken the 18th.
Yes, so we've taken Tuesday the 18th at 11 o'clock virtual.
Okay. Okay. So those are the orders and directions issued by the court. And the accused persons are hereby formally informed that they have a right of appeal to the Court of Appeal.
My lady, you did not talk about my request for the judgment. I do not know if you have it
Okay.
ready.
The judgment is here with me, is typed, but of course I will need to proofread it just to correct a few typos here and there and to polish it up a bit. So I will require your indulgence because it's a very long judgment, as you must have noted. So it will take me a bit of time to finish with the proofreading. But probably by early next week, it should be published. And I will also make an order that you be provided and a general order that any of the councils be provided with a typed copy, but of course upon payment of the requisite fee.
Very well, Madam. Even uploading it to the CTS will be fair enough.
Okay.
Yes.
And do we take time, specific time for the mention, or do we just
Yes,
say
I thought we said 11. We've agreed on 11 a.m. So if there is nothing else, then I think it's a good time to adjourn.
practice that?
Shughuli tu. Sisi ni watu wa mkono ila
This thing is real. For sentence. Yeah,